This is Michael Popok, Legal AF. The 11th Circuit Court of Appeals, based in Atlanta, has issued a series of scathing rulings that impact all things Trump, including whether he's going to ultimately be able to get his Georgia prosecution that's in state court over to a federal judge as a first step to try to apply some sort of presidential immunity or sovereign immunity. But all roads first go through Mark Meadows. Mark Meadows, having taken the first appeal when he tried to remove or transfer his case from state to federal court under a federal officer removal statute that's on the books, but the 11th Circuit decided to make new law in 190 years, and it was all against Meadows and Trump, and also impacted Jeff Clark, the former Department of Justice number 7 on the totem pole, on the hierarchy, who also was the acting attorney general for about, a minute and a half during the waning days of the Trump administration. Take a listen to our most recent episode of Legal AF.
Importantly, the 11th Circuit Court of Appeals, in two decisions this past week, Michael Popok, I think are holding hands with their sister court in the D.C. Circuit Court of Appeals and the 11th Circuit in a different context. Yes, it's a scathing order against Meadows. Yes, it's a scathing order against Jeff Clark on the issue of federal officer removal. But there's a broader point that I think the 11th Circuit is making here, which is it is outside the color of your official responsibilities as purported officers when you engage in this interference with elections and you are acting like you're arms of the campaign. And then, of course, when you're engaging in efforts to overthrow the results of the election. But these are not areas you're supposed to be in. And Donald Trump, if these are areas you go in, okay, you're just not going to have immunities that we give to the commander in chief and to the executive when those immunities are intended to protect people who are protecting our democracy and carrying out their constitutional duties, not whatever you're doing on Newsmax and Fox News and all of those other things. So the issue when it came to Meadows and Clark were co-defendants of Donald Trump's in the Fulton County District Attorney RICO indictment. The case was filed in state court, a criminal case in Fulton County Superior Court before Judge Scott McAfee. And Meadows and Jeff Clark removed the case to federal court under the federal officer removal statute. When you remove it, the removal happens automatically. So the case that was in state court gets automatically transferred to federal court. And then there is a hearing that takes place in federal court where it's disputed that they had the right to move it to federal court about whether it stays in federal court or whether it gets remanded back to the state court, sent back to the state court where it was filed. And then ultimately what Meadows and Jeff Clark were trying to set up was a two-tiered approach where once they were in federal court, they were going to say that they are immune and they have sovereign immunity and they can't be prosecuted by the state and they have other immunities as well. And then the case should automatically be dismissed. But part one of their plan, they wanted to get into federal court. And so the district court judge denied the federal officer removal. Then it went to for both of them, for both Clark and Meadows. And we covered those hearings here. Meadows testified and basically incriminated himself and admitted to having Hatch Act violations. Jeff Clark had it was just procedurally didn't even know what the heck he was filing. Like it was like just a horrific hearing that took place. And the judge was like, "You're not even introducing evidence. I don't even know what it is that you're doing here." But then Meadows filed an appeal to the 11th Circuit, and the 11th Circuit went above and beyond what the district court judge did and said, actually, federal officer removal is not allowed for former federal officers. So number one, Meadows, you're not the chief of staff anymore. So on that basis alone, you didn't have the right to remove. You're a former federal officer. Only current federal officers can remove, which wasn't even analyzed by the district court judge or the Fulton County District Attorney, although we talked about it here on Legal AF as an issue in real time. And then the 11th Circuit then called on that issue to be briefed among the others. But then the 11th Circuit basically, as I said, went on to say, look, this is not within your authority at all of Mark Meadows within Article 2. You're involved in Hatch Act violations. You're involved like in campaigning and elections and overthrowing the results of the elections. And just your behavior is not something a chief of staff is supposed to engage in or that the president's supposed to engage in. They said that. This is not conduct of the presidency. This is someone who's running for office and is engaged in crimes to overthrow it. That was an important signal. And then very swiftly, they then moved to Jeff Clark. Jeff Clark had not reached the appeal stage yet with the 11th Circuit. He was seeking a stay of the district court proceedings and all of the lower court proceedings in order to pursue an appeal. And then the 11th Circuit said, why would we grant you a stay? You just saw what we did to Meadows. We just basically called Meadows a criminal. And we said former federal officers cannot remove the cases and that his conduct was outside the color of his official federal responsibilities. So why would we allow this for you? You have no chance of succeeding on your appeal. So before the appeal is even heard, the 11th Circuit's telling Jeff Clark, this disgraced DOJ official who Donald Trump wanted to make his acting attorney general, to send out a letter in 2020 and 2021 to all of the states telling them to overthrow the results in their states and lying about there being fraud. And that's why the state should name Trump as the president. Jeff Clark was the person who Trump wanted to appoint as acting AG. All the other people in the Department of Justice said they were going to resign, and then Trump backed down. But that's a message that the 11th Circuit sent to Jeff Clark. But to me, Popok, and this is the take that I want to hear from you, and then I want to hear about the Colorado Supreme Court from you, I thought the 11th Circuit was going a step beyond here intentionally, because they could have ended their analysis just at federal officer, and saying you're a former federal officer, that's it. But they spent a lot of pages in the Meadows decision and then just swatted down Jeff Clark. To me, they were saying we are in the 11th Circuit's conservative. I think they were saying we're conservative in the 11th Circuit. We ain't MAGA. We are conservative. This MAGA stuff, we're not okay. We're not okay with it. That's to me what was really resonating on those pages.
Yeah, I agree with you. I think Bill Pryor, who's the chief judge of the 11th Circuit, who we've talked a lot about on the podcast because he's been involved with some of the most momentous decisions short of the D.C. Court of Appeals and the U.S. Supreme Court involving Trump and MAGA since the very beginning. He's the judge that presided over at least one of the major decisions that told Aileen Cannon, what are you doing as a trial judge? You're not supposed to interfere with the executive branch and the Department of Justice and FBI during a pending investigation. Your work starts when there's an indictment and not before. And so we knew, because when we're doing the map and the grid on Legal AF, Ben, you and me have always said that there are districts, there are courts of appeal that we worry about. Fifth Circuit being first among them because it's so right-wing MAGA and packed by Trump a lot. And this is where all those decisions about a woman's right to choose and the ability to use the abortion pill and the ability for Joe Biden as commander-in-chief to make regulations about COVID policy. When there's a wacky case that's a head scratcher that tries to stick their thumb in the eye of the Biden administration and against women's rights, it's coming out of the Fifth Circuit. The 11th Circuit is not monolithic, though. It does lean right, but as you just put so properly, it doesn't lean MAGA. And yes, it was most of the people on there, most of the judges on there were appointed by Republican governors, whether it was DeSantis or Rick Scott, or even going back in time in Florida and in Georgia, because it's the circuit where Georgia and Florida and Alabama send their judges. We were a little worried at the beginning. We took some comfort in the original decisions against Aileen Cannon's case, in the case of Mar-a-Lago that we talked a lot about. And now we've got the 11th Circuit with the spotlight on them, the way it's on the D.C. Court of Appeals almost at the same time, making decisions that matter about things coming out of the Georgia prosecution. And you're right, because Bill Pryor, who wrote that decision that you're talking about Mark Meadows, which was then the precedent, to continue with our imaginary bookcase, the precedent that was cited a week later in the Jeff Clark dismissal of his, you're not going to get a stay. You're not even going to win your appeal. Have you read the Meadows decision from just last week, which we're relying on? And what they could have done is just said, as the that it doesn't apply to former federal officers. They made a decision that in 190 years, no federal court has ever said about the federal removal statute 1442A on our books. They said it only applies to current, not former federal officers. Would you believe that in 190 years of jurisprudence, no federal court had ever taken on that issue? It's hard to believe. But they said, we know it's different, it's momentous, but nobody, but we're right on the law. We're so right. Think about this, Ben, and then I'll get to what Bill Pryor said in his order that you're referring to. We're so right that even though at least one of the three judges on that panel, Judge Rosenbaum from Miami or from Florida, even though she said that it agreed with the majority position that it doesn't apply, the removal statute, to take your case, your state criminal case, across the street to federal court as a way to get the case dismissed ultimately under the supremacy clause or otherwise, that she said Congress needs to go change that statute. She believes that the better public policy is that it does apply to former federal officers. She just can't make her way through it based on the legislative history and the language of the statute and the way, when you read the different provisions of the statute, trying to glean congressional intent. She says, I tried. I am in favor of it applying to former federal officers by Mark Meadows. Doesn't answer the question as to whether, looking at the facts as alleged and presented and developed in the hearing in front of Judge Jones down in the Northern District of Georgia, whether she would have found that Mark Meadows met the test. But the fundamental issue first, whether it applies to former or current occupants of that office, she said, I'd like it to apply to former. I just can't get there. Congress needs to make that change. That was a very interesting dissent. But here's what Pryor said, I think is right on the money for what you're talking about. He said that we, this is a quote from the case, we cannot rubber stamp Meadows' legal opinion that the president's chief of staff has unfettered authority. At bottom, whatever the chief of staff's role with respect to state election administration, that role does not include altering valid election results in favor of a particular candidate. Scathing. They didn't have to go there. They could have just said, it doesn't apply to a former, we're done. Bye. No. They wanted to comment on the indictment and the allegations and the fact that Mark Meadows, as alleged in his indictment, went beyond that. Or as Judge Abadu said, the Biden appointee said in her oral argument, what about the Hatch Act? Why isn't the things that you're talking about not only not within the scope of your authority, even if we stretch it to its outer limits, like some sort of constitutional silly putty? Why isn't it a Hatch Act violation? All the things that you say the chief of staff has to do as part of getting a first-term president, a second term. Why isn't that campaigning while in office and a crime under our statutory system? That was never properly or accurately answered or appropriately answered by the Meadows side. So I agree with you. You have the 11th Circuit, a small c conservative Republican, not MAGA bench, who now on a number of occasions has gone against Donald Trump, properly citing this jurisprudence. Now, you and I knew that something was up with the former federal officer issue because there was a prior ruling in the 11th Circuit in October that happened right around the time of the briefing. And they asked the parties to especially brief the issue of whether former federal office holders get the benefit of that removal statute. That is something that was not addressed below by the trial judge. In fact, as everybody in 190 years has argued, everybody thinks that at least every prosecutor, even judges, thought if they were asked the question, it would have applied to a former federal officer as long as the other elements are present for removal. That the thing that you're alleged to have done wrong civilly or criminally, is within the ambit, the scope of your federal office, the color of your federal office, and you have at least a good faith, colorable federal defense to this particular action, then you're okay. I mean, even the judge in the E. Jean Carroll case, who tried, in the Stormy Daniels case, when Donald Trump tried to bring it over to federal court over the summer, assumed that even though Trump was no longer a federal officer because he was no longer president, that the statute would still apply, not for the 11th Circuit. So I really appreciate the I'm trying to think of the word, the conviction by which, no pun intended, the 11th Circuit has decided that they needed to solve an equation that hasn't been addressed in 190 years, and they needed to apply it. And they took on the weight of that responsibility because that's what they get paid to do. We're going to talk about the Colorado Supreme Court justices that said virtually the same thing in their decision against Donald Trump's position, which is this is a weighty decision, but this is what we get paid to do as civil servants wearing the black robes. And if anybody takes anything away from any aspect of watching Legal AF or any of the hot takes that the leaders of Legal AF do, it's that there are people in our system that are dedicated public servants who aren't corrupt, who aren't part of a conspiracy, who aren't, falling down the rabbit hole of some QAnon theory. They're just doing their job assigned to them by their respective state or federal constitution. They've taken an oath, and that's what we're watching. It can't be the situation. It cannot be the situation. And I refuse to accept it, that the only reason Donald Trump has gotten indicted and is losing regularly in these courts is because there must be corruption and or a conspiracy theory against him involving the prosecutor, the Department of Justice, the FBI, the state prosecutors, and the judges. I refuse to believe that that is the system of government and the justice system, state and federal, that has developed before my very eyes for the last 50 years. Welcome back. If you know all about Legal AF on the MeidasTouch Network, welcome back. We appreciate you, and thanks for being along for our journey. If you have no idea what I'm talking about and who I am, I'm Michael Popok. That was Legal AF. We do it every week on Wednesdays and Saturdays at 8 p.m. Eastern Time on a podcast that we curate at the intersection of law, politics, and justice we like to call Legal AF. It's exactly what you think. So until my next Legal AF, until my next hot take, this is Michael Popok reporting.
Thanks so much for watching. We're only a few subscribers short of 2 million subs. Please subscribe right now to the MeidasTouch YouTube channel for free and help us grow this unapologetically pro-democracy network.